morning, everybody. We meet today for Shurat HaDin's third annual law conference on the law of war and its application to the modern battlefield, at an important moment of remembrance and the perspective it offers in the aftermath of the 70th anniversary of the Universal Declaration of Human Rights, known as the Magna Carta of International Human Rights and the foundation and cornerstone of international humanitarian law, marking the 70th anniversary of the Geneva Convention of 1949 and approaching the 5th year of HaDin Goldin's captivity that the President just referred to. With that as background, the organizing theme for my talk today, and I express my heartfelt appreciation to Shurat HaDin for the opportunity to address this important audience, is on the Goldin case and cause in view of UN Security Council Resolution 2474. In this context, I would be remiss if I did not elaborate on the history of the Goldin case and the UN Security Council, the UNSC. On December 22nd, 2017, the UNSC held a special session on international humanitarian law and on the repatriation of the remains of HaDin Goldin and Oron Shaul, two Israeli soldiers abducted and murdered by Hamas during the 2014 Gaza war. This historic hearing of the UNSC was co-hosted by the United States and Ukraine, at which former Minister of Justice and Attorney General of Canada, my father and teacher, Professor Erwin Kotler, described the situation as a standing violation of international humanitarian law, and abiding disrespect and denunciation of the UN itself, its values, institutions, and norms. And he sends and extends, including this morning, his success for this conference, Michal, and his apologies he's not here. Security Council members and other UN member states expressed their unanimous support for and solidarity with the Goldin family, demanding the return of the remains of HaDin Goldin and Oron Shaul. The countries highlighted that the refusal to repatriate the remains of murdered soldiers constitutes an egregious violation of the most fundamental principles of human rights and human dignity that underpin humanitarian law. Participants reaffirmed that the Secretary General and international organizations must work to secure the return of the remains, lest the international community itself indulge a culture of impunity in defiance of UN norms. In her testimony before the Council, Dr. Leah Goldin, Hadar's mother, described her son. Hadar was an Israeli humanitarian and artist, painter, graphic designer, poet, and an inspiration to all who knew him. He was also a soldier. In addition to the standing violation of the refusal to return Hadar's remains, the entire Goldin family is experiencing the unspeakable plight and pain of being unable to exercise their right to bury their son, to grieve, and to continue their lives painfully without him. As mentioned, the incident occurred in violation of a UN-mandated ceasefire and is itself a violation of international law regarding the return of remains of deceased in the context of armed conflict. The international community must take responsibility and hold the Palestinian Authority to account, given that the PA bears direct responsibility as party since 2014 to the Geneva Conventions and the ICC. Further, the Security Council hearing noted that special responsibility of NGOs claiming a human rights mandate to champion demands that Hamas comply with international laws and norms and return the bodies of Goldin and Shaul. Organizations such as Human Rights Watch, Amnesty International, and others should be among the world's leading voices in holding Hamas accountable for such violations of international law. The voices of these NGOs should be heard on this issue in the United Nations, in the parliaments of the world's democracies, the media, and every other platform. As the International Committee of the Red Cross put it, and as is cited by the hearing co-chair from Ukraine, and I quote, "Missing persons, regardless of their status, soldiers fallen or captured during fighting or civilians taken captive by an adverse party are protected by humanitarian law, and intentionally withholding information about missing persons is acting in violation of international humanitarian law." The representative and hearing co-chair from the United States expressed that, and I quote, "Hamas murdered and seized the remains of HaDin Goldin in violation of a UN-mandated humanitarian ceasefire in which the United States joined in and mediated at the time, while continuing also to hold the remains of a second murdered Israeli, Oron Shaul, and where, on 2 other occasions, Hamas captured and continues to hold Israeli civilians Avram Mengistu and Hisham el-Sayed, both mentally disabled, deprived of their liberty, and deprived of their right to be reunited with their families. In view of this historical hearing, it was especially meaningful to learn of UN Security Council Resolution 2474 on missing persons recently passed. Reiterating the unequivocal and unanimous support sounded at the hearing, the resolution speaks of the imperative to return missing persons to their families for burial. It requires all states, the UN, its institutions, and all its representatives to uphold and protect the basic right of families to bury their loved ones. Clearly addressing situations of conflict and war, it regards this basic humane act as a preliminary, confidence-building measure necessary in order to advance the possibility of end to conflict or peaceful resolution. Furthermore, it requires all those involved in negotiations or funding towards end of conflict to take responsibility in order to uphold and protect its requirements or be held to account if they fail to do so. Before I briefly review the foundational principles of international human rights and humanitarian law as reflected in and represented by this case and cause, in particular in view of Resolution 2474, and which relate directly to the subject matter of this conference, allow me to get a little personal. My father, my teacher, has inculcated into all that know him the imperative to always remember and never forget that behind the cases are human beings, their families, and the unspeakable pain and suffering which they are enduring and for which we must stand up for and sound our voices. Therefore, it is imperative to highlight and champion this individual case and cause of Hadar Goldin and of his family members if we are to change the broader reality, of which it is but a symptom. First, the families of the deceased and the missing have a fundamental right anchored in international humanitarian law to seek and be informed of the status and situation of their loved ones, the denial of which by Hamas for nearly 5 years is a source of ongoing pain and suffering for the families. Second, Hamas is not only withholding information or tauntingly dissembling that information, but continues to refuse to return the remains of Hadar Goldin and Oron Shaul, yet another egregious standing violation of a foundational principle of international humanitarian law. Third, Hamas has engaged in a standing violation of fundamental precepts of human rights and human dignity, which underpin the Universal Declaration of Human Rights and which find expression in the Geneva Conventions and customary international law, including the First Geneva Convention. Fourth, Hamas is also in standing violation of the agreed-upon standards of behavior and respect in the Islamic world, as set forth in Article 4 of the Cairo Declaration of Human Rights in Islam. This is a universal principle which Leah Goldin referred to at the Security Council hearing, common to Islam, to Christianity, and to Judaism. Accordingly, Hamas's standing violation of these norms of customary international law is also a standing violation of international humanitarian principles of these religions. Fifth, the Palestinian Authority, as well as Hamas, is implicated in the standing violation of international humanitarian law. For on October 12, 2017, Hamas and the Palestinian Authority entered into a reconciliation agreement wherein the Palestinian Authority assumed jurisdiction over Gaza as well as the West Bank. Yet, the PA has not condemned or remedied the withholding of information by Hamas regarding missing persons in their jurisdiction. It has not condemned or remedied the continued refusal by Hamas to return the remains of the deceased. As such, it has not only failed to hold Hamas accountable, but participates in nurturing the culture of impunity surrounding these violations of international humanitarian law. Sixth, Hadar Goldin, as mentioned, was murdered and his remains seized in violation of a UN-sanctioned, US-brokered, EU-supported humanitarian ceasefire on August 1st, 2014. The standing violation of international humanitarian law by Hamas, regrettably aided and abetted by the Palestinian Authority, is not only a standing violation of the humanitarian ceasefire, which would be bad enough, but now also a direct violation of Resolution 2474 on missing persons, which cements the foundational United Nations principle to respect and protect international peace and security. Seventh, such action and inaction by the Palestinian Authority not only constitute a standing violation of international humanitarian law, but as the Palestinian Authority has joined the International Criminal Court and invested in its jurisdiction over crimes in the West Bank and Gaza from June 13, 2014, it is in standing violation of the Rome Statute. Accordingly, Hamas is also in standing violation of the International Criminal Court prohibition against committing outrages upon the dignity of the deceased, withholding the remains of Hadar Goldin and Oron Shaul, subjects the Palestinian Authority as a responsible governing party to accountability before the International Criminal Court if it does not, as it can and it must, remedy this ongoing and outrageous violation. In conclusion, having marked the 70th anniversary of the Universal Declaration of Human Rights, marking the 70th anniversary of the Geneva Convention of 1949, approaching the 5th year of Hadar Goldin's captivity, and in view of the recent UN Security Council Resolution 2474, we are witness to a critical mass of violations of international humanitarian law and of the principles and purposes of the United Nations and its institutions designed to promote and protect these principles. The United Nations, its member states, its institutions and representatives have a responsibility to protect those who are protected persons under international humanitarian law and those who are missing persons under Resolution 2474. Furthermore, the United Nations, its member states, its institutions, and its representatives, as the trustees of international humanitarian law and as the trustees of international peace and security, have an individual and collective responsibility to act. The ongoing and standing violation of principles of international humanitarian law generally, and Resolution 2474 specifically, are compounded by the silence, the inaction, and the culture of impunity of all those with the legal, moral, and religious duty and responsibility to uphold and protect them. My father often quotes his friend and Nobel Peace Prize laureate Elie Wiesel, who warned of the danger of indifference and inaction in the face of evil, who spoke of our responsibility always to speak and act against injustice in the pursuit of justice, warning us that indifference always means coming down on the side of the victimizer and not on the side of the victim, reminding us of the imperative of our commitment to the basic principles of international humanitarian law, which inspire this annual conference and the important work of Shurat HaDin. I urge us all to consider the important topics that this conference will raise, including the panel on Gaza later today, through the lens of the Goldin case and cause, in view of Resolution 2474. Offering significant intersectional insights to the broader topic as a proverbial canary in the mine shaft. Further, I would suggest that if we are to comprehend and address the current challenges, some of which were introduced, of the laws of war and their application to the modern battleground in view of the reality of the asymmetric war between law-abiding states and genocidal terror organizations, this case and cause has powerful global relevance and lessons that underpin the shortcomings of current paradigms and highlight the necessity to examine and understand current challenges to the foundations and precepts of international humanitarian law. It is imperative to combat the culture of impunity which continues to surround these violations and the outrageous silence accompanying it. It is our responsibility to send a message to the families that they are not alone, to stand in solidarity with them in their deep pain and suffering, to act relentlessly until justice is secured not only for them, but for the abiding integrity of the foundational principles of international humanitarian law, demanding the return of the remains of the deceased and the release of the missing. The pursuit of international peace and security demands that the overriding principles of international humanitarian law be upheld, promoted, and protected. Thus, the return of Hadar Goldin to his family for proper burial is an imperative first step, a confidence-building measure in the ongoing pursuit of prosperity, peace, and security in the Gazan context and beyond, rather than a hindrance to it. Upholding and protecting the rights of the Goldin family to bury him has the power to release civilians cruelly and intentionally held hostage by Hamas, a genocidal terror organization on both sides of the border. May this not only be a moment of remembrance and reminder in the aftermath of the 70th anniversary of the Universal Declaration of Human Rights, the Geneva Convention, and the 5th year of Hadar's captivity, and marking the recent passing of the UN Security Council. May it also be a call to action for each and all of us, individually and collectively, in Israel and internationally. Thank you.